Good morning and welcome to the session 3 of 6 of the Water Bootcamp. My name is Laura Ramos and I will be your MC for the session. This bootcamp covered hydrology and where your water comes from earlier today and will be available for viewing via the World Ag Expo show portal until February 28th. During this session, we will cover surface water rights, followed by groundwater, CV salt, and a blueprint for water in the San Joaquin Valley tomorrow. The bootcamp is brought to you by the California Water Institute at Fresno State, which mission is to engage the San Joaquin Valley, California, and the world with Fresno State faculty, staff, and students in the pursuit of a sustainable water resource management solution through outreach, research, and education. The California Water Institute would like to give a special thanks to World Ag Expo for allowing us to present this information today. We wish we were with you in person in Tulare and hope that next year we can present this information to you in person. Questions will be taken at the end of the session, but please feel free to add them to the chat function on Zoom or on the World Ag Expo show portal as we go. The session speaker is Tom Holyoke, Professor of Political Science at Fresno State. Tom?
Hello everyone at the Ag Expo. My name is Tom Holyoke, Professor of Political Science at Fresno State, and, among other things, I teach a course on Western water policy and law. Thanks to the California Water Institute for inviting me to give you a brief, very brief given the complexity of the topic, overview of water rights in California. Water is scarce in the American West, so it is crucial to know who owns it and who has the right to use it. Unfortunately, it is so scarce, water is, that laws regarding the right to use it have become incredibly complex. First off, there is a crucial, if somewhat esoteric, distinction between owning water and the right to use it. All surface water in California, meaning water in rivers and streams, is ultimately under the control of the people of California. Effectively, we collectively own the surface water in the state and even set broad parameters on its use. However, when we talk about water rights law, we are talking about who has the right to use the people's water, who has the right to divert it out of a river for private use. The right to use water, or the right to gain a material advantage from using it, is a private property right. It is the legal concept of usufruct, a distinction defined here. It is an odd distinction, but when one diverts water, one does not own the fluid. The people of California own that, but the individual owns the benefits of using the fluid. Nonetheless, whatever the use it is put to, the state constitution, recognizing that much of California is arid or semi-arid, seeks to ensure that water is used wisely and not wasted. Having said that, we often have different competing ideas as to what is a wise use and what is waste. That is a big part of the reason why water rights are so politically contentious in California today. There are elements of water rights law that go back to the Spanish conquest, such as the Pueblo water right. But California water law, and really Western water law generally, begins with the gold rush of 1849. In order to find gold, miners used water for a variety of purposes, especially for hydraulic blasting, using the pressure from diverted water to crack open rock. How miners claimed water was similar to the way they claimed a vein of ore, on a first-come, first-served basis, which is now the basis of the legal doctrine of prior appropriation. At the point where the water was diverted from the natural river to the miner's ditch, a miner posted in writing information regarding where the water was being diverted to, who the miner was, and how much water was being taken. It really did not make any difference how far the miner diverted the water. That was at their own expense. But because water was scarce, what they used the water for, how much they took from the river, and when they claimed it mattered a great deal. Miners could only take as much water as they needed for the purpose specified on their diversion notice. As long as these basic requirements were met, the miner had what amounted to a private property right to use that amount of water, but only that amount of water. Hoarding was forbidden. Originally, all of this was not in law, for there was no clear set of laws in 1849, merely a custom, but one accepted by miners because respect for one claim meant that another miner's claim would also be respected. It all became law in 1851 in California, and soon after in other southwestern states. Today we refer to this method of claiming water rights as the law of prior appropriation, or the appropriative right to use water. An easier way to think about it is simply first come, first served, though usually we use the phrase first in time, first in right. Basically, it works today the same as it did during the gold rush, though since 1914 claims to divert water must be formally filed with the California State Water Resources Control Board, rather than just by posting a sign. But not too many new claims are issued today, as there is little free water left to claim. Here are the 4 most important characteristics of prior appropriation. The most basic is that the first person claiming water from a river has a right to absolutely all of the water claimed for diversion before the next person, who filed the claim later in time, gets any at all. It is important to understand this harsh-sounding doctrine. In a drought, if there is only enough water in a river to satisfy the first filer's claim and none for any later filers, then too bad for the later filers. The first person's claim must be entirely fulfilled, even if it means the other claimants get no water at all and lose everything. This is what we mean by first in time, first in right. Prior appropriation is a pretty good law for arid lands because water availability on land is not part of the law. It does not matter how far the river of origin is from the point where the water is used. As a practical matter, the closer the use point is to the river, the less capital cost the diverter has for building a canal, but that is irrelevant from a legal point of view. Geographic location of water and water use does not matter, only the temporal seniority of the claim in the doctrine of prior appropriation. Also, the water cannot be stored for a later date when the claimer might need it. It must be used for a practical purpose, such as agriculture, under the legal requirement of beneficial use. Generally, I believe the appropriator typically has 5 years to use the water for some productive purpose, or the right can be lost, and seniority passes to the next senior-most appropriator of water on the same river. Today, the Water Resources Control Board tends to make these decisions, though, as you can imagine, it is often litigated in court. I also list here a few examples of accepted beneficial use. It is also worth pointing out that appropriative rights are not really tied to the land. If land is sold, the water right does not automatically go with it. Selling appropriative water rights themselves has become contentious, and some counties and irrigation districts have tried to prevent sales of water rights in the valley to, say, Southern California. Nonetheless, water markets are becoming an increasingly important part of the future of water in California, especially with SGMA, the new groundwater law. Okay, now to make things more confusing. Most of the 17 Western states use prior appropriation as their only real law regarding the use of water, but not California. We have a whole second law largely at odds with the way prior appropriation works. When California was admitted to the Union in 1850, it adopted the English Code of Common Law, as did many other states. This included the legal doctrine of riparian rights when it came to water usage, which is the form of water law used by much of the eastern United States. However, in the East, there is a lot more water and many more rivers. For those states, the riparian law makes sense because the right to use water is tied to whether a river or creek crosses, or at least borders, a person's property. And in New England and the Mid-Atlantic, this is not all that unusual. And in any case, there is usually plenty of rain in that part of the United States most of the year. But in the arid West, such a law like this makes less sense. Where prior appropriation is concerned with claims in time irrespective of location, riparian water rights is all about location irrespective of time. In riparian law, water is tied to the land in the sense that the right to use water exists when a person's land borders or wholly contains a river. Thus, the water right cannot be sold unless the land itself is sold, in which case the water right goes with the land. An owner of land not physically connected to a river cannot really assert any claim to water under riparian law. More importantly, the owner of land with a river who claims water under riparian law can take all of the water he or she wants from the river. In pure riparian law, there is no requirement of beneficial use, so water can be stored. However, the landowner cannot take so much water that it causes problems for other landowners on the same river. Upstream riparian claimants do have a greater claim, but this priority is not so great that any riparian user can simply take all of the river's water. This is an important difference. Prior appropriations water users can take all of the water they are entitled to with their seniority, while riparian claimants can take all of the water they want as long as they don't seriously hurt other riparian claimants. Under riparian rights, there is a basic requirement that they significantly accommodate downstream users, what's called a correlative right. If you find all this a bit confusing, you are not alone. Great legal minds have beaten their heads against walls trying to work out all the subtleties of the correlative right. As you see here, California and 9 other states use both appropriative and riparian legal systems. Pretty much all of the other southwestern states, though, just use appropriative. How does California reconcile these two contradictory legal doctrines, especially since individuals are free to use either, but not both, to claim the same water? Well, unsurprisingly, it involves decades of litigation. I'll let you just look at this slide for a moment. Well, I will spare you all of the gory details of the famous Looks versus Hagen court cases of 1879 and 1886. On one side was James Ben Ali Hagen and William Carr, who owned the Kern Land and Water Company south of Bakersfield, who took water from the Kern River under the prior appropriation law. But further down the river near Bakersfield was land owned by Henry Miller and Charles Looks as part of their vast valley ranching operation, but they took water from the Kern River under the riparian doctrine. As long as there was adequate water in the Kern, there was no real problem. Then, as always, there came a drought. And when Miller refused to let Hagen have any water, the latter responded with rivers of litigation. This gets a little complicated, and some people take whole courses on this in law school. The state Supreme Court ruled that riparian law did trump prior appropriation law, so that riparian rights was the commanding legal doctrine, except that the court retained the importance of the time a water right was filed, which, of course, is the heart of prior appropriation. Essentially, the court started applying first in time, first in right to riparian claims. Doesn't that make it a lot clearer? Basically, water must be claimed in line with the riparian doctrine. But if a prior appropriations claim was made for water in the same river before a conflicting riparian claim was made, and the water was being used for a beneficial purpose, then the prior appropriation claim is still superior to the riparian claim. Prior appropriation claims on a river could still be filed after a riparian claim, but they would be inferior to the riparian claim, and, more importantly, the riparian claimant is not held to the same standard of beneficial use as the prior appropriator. As I said, this is confusing. Perhaps think of it this way as you read these excerpts from the California Water Code. A person with a riparian claim can take all of the water he or she wants, no matter what the impact is on other prior appropriator claimants, as long as the prior appropriator's claims are filed later in time than the riparian claim. However, if a second riparian claim is made, the two riparians more or less must share the water, regardless of when in time the claims were filed. While this gives protection to older claims under prior appropriation, all claims made subsequent to the Looks v. Hagen decision you would think would be riparian if the claimant is smart and owns land along the river. Well, take a moment here to look through the bullet points here. There are also other variations in this, such as priorities given to cities in the temporal ordering of water claims. It is also worth pointing out that because the state's legal doctrines are far older than the State Water Resources Control Board's permitting system, which only goes back to 1914, the state has a very hard time sometimes trying to verify the dates of old claims. While appropriators needed to file paperwork prior to 1914, these papers may no longer exist anywhere. There is an even bigger problem with riparian claimants because, given that it is a property-based claim, it was often not clear if riparian claimants needed to file any paperwork with anybody at all. In the Delta region, where the Sacramento and San Joaquin rivers meet, about 2,700 of 3,000 water rights claims are riparian, and often there is no documentation. They are very, very old claims. This was a big problem during the drought of 2015, when the state was trying to figure out who had priority when water deliveries had to be greatly reduced. Unsurprisingly, a lot of people were claiming very, very old water rights, which would theoretically have protected their water claims, except very often they did not have the paperwork to back that up. It was a messy situation, and again, it unleashed rivers of litigation. In addition to these major water doctrines, there is the aforementioned Pueblo water right, giving some California cities that started as Spanish missions rights to the water in the rivers passing through them, rivers that were essential to the old Spanish missions. A much more significant legal doctrine is called the public trust, which emerged in the fight over Mono Lake on the eastern side of the Sierra. The courts found that the state of California had an overriding obligation to maintain navigable waterways, and the streams feeding them for public use, and this trumped private water rights claims. It is not clear what the full extent of this public trust doctrine is, but a few have speculated that it could allow the state of California to extend its control over groundwater, though the state has not really tried that yet, to my knowledge. Finally, a 1908 U.S. Supreme Court decision held that Native Americans can claim a water right which has a temporal priority at the date their reservation was created, regardless of whether they were actually diverting water at that time. That means many, probably most, Native American reservations or rancherias probably have very, very old water rights. A subsequent 1963 U.S. Supreme Court decision held that Native Americans were entitled to enough water from rivers or rivers that bordered their lands or went through their lands to service all practicable irrigable acres. Some have calculated that means Native Americans can claim the entire natural flow of the Colorado River. While these claims have not been aggressively pressed, they are still a big unknown in the tapestry of California and all Western water law. Just a note to end on here. Who has the most water rights in California? According to data collected from the State Water Resources Control Board and made available by the Legislative Analyst's Office a few years ago, by a long shot the biggest holder of water rights is, and perhaps unsurprisingly, the U.S. Bureau of Reclamation, which needed to acquire water rights in order to operate the massive Central Valley Project. The same is true with the State Department of Water Resources and its State Water Project. Otherwise, it is irrigation districts like the one down in Imperial Valley and energy companies operating hydroelectric dams that have the most water rights. Well, thank you very much for listening, and I believe we'll be coming on live here in a moment to take any questions that you might have. Thank you.
At this time, we would like to answer some of the questions that came in via the chat. If you have additional questions, feel free to insert them now. Thank you for joining us for this session. We hope that it was informative. The session was recorded and will be available via the World Ag Expo platform until February 28th. Thank you.